Well, I don't know if it was surprising, but one thing that stood out was that oftentimes they will not ask an attorney on the front end. They will try and do something on their own and shape some sort of solution, and then come to the lawyer after the situation arises where it's clearly now a legal issue. You know, somebody's being sued or somebody needs to enforce some sort of contract, somebody's not performing, right? Um, it's not necessarily that it's surprising that people try and do it on their own, it's just how often.
Welcome to Sterling Insights, Stand Out and Supercharge Your Assets, the go-to podcast for financial advisors aiming to grow their assets under management, stand out in a crowded market, and retain assets nearly forever. Are you advising high net worth clients who own appreciated capital assets? Do you want to help them sell without losing a quarter, a third, or even more of their hard-earned profits to capital gains taxes? Then this podcast is tailored for you. Each episode brings you the latest strategies and expert advice from leading financial advisors, seasoned attorneys, and experienced CPAs. Learn how to maximize your clients' wealth, minimize their taxes, and supercharge your advisory practice with actionable insights. Join us on Sterling Insights, Stand Out and Supercharge Your Assets, where you'll gain the knowledge and tools to set yourself apart and achieve unparalleled success in wealth management. Subscribe now and empower your practice for a brighter, more prosperous future.
Okay. Welcome back to Sterling Insights. I'm Seth Krussman, and today we're focusing on an area of business that quietly shapes outcomes long before problems ever surface: legal strategy and decision making. And joining me today is Blaine Clooten, an attorney at Brownstein Rask, a Portland-based firm known for advising businesses, entrepreneurs, and executives through complex decisions with a practical business-first lens. And in this episode, we're going to talk about how legal risk is actually showing up in real life, contracts, partnerships, employees, growth decisions, and how business owners can think more proactively about law as a strategic tool, not just something to deal with when there's a dispute. When there's a company that you're running and investing in, one of the advising business owners like yourself today in today's conversation will help you spot issues earlier, make decisions better, and ultimately protect what you're building. Blaine, welcome to Sterling Insights. It's great to have you here.
Great to be here. Thanks, Seth.
Can you tell me a little bit about your background? Just walk us through your path into practicing law and what led you to focus on advising in businesses, and like you were talking about, generalist as well. If you can kind of give us the feel for that.
Sure. So prior to law school, I actually worked in the business world for about 7 or 8 years. So following undergrad at U of O, I sold everything from umbrellas to software. And I ended up working down in San Francisco for a startup called Splunk for a while. They have
Heard of it.
since gone public and been bought out. But in the Great Recession of 2007, 2008, I had kind of a awakening of sorts and had to make a decision about where I wanted my life to go. Was I going to continue down the sales path? Was I going to do something else? And growing up, I had always been fascinated by the John Grisham books and always had lawyer in the back of my head. So I decided to try taking the LSAT and the GMAT and did better on the LSAT. So I went to law school. And it became kind of this funny Forrest Gump thing where, you know, I came this far, I finished law school, I might as well keep going. So I took the bar exam. And when I became a lawyer, the job opportunity holdover effect from the Great Recession was that law firms still weren't really hiring. And so my then girlfriend, now wife, and I decided to take opportunities where they arose, and they arose out in Eastern Oregon. And so we were in Pendleton, Hermiston area in Oregon. And one of the nice things about being in a rural area is that you're required almost to be a generalist. I mean, people, I call it door law. Whatever walks in the door, that's the law you're doing that day, because there aren't enough practitioners to go around. There's more people than attorneys. There's problems that vary from person to person, but there's quite a bit of crossover. And it gives you an opportunity to ply your trade in more than one way and solve more than one problem at a time for people. In 2023, my wife and I decided to move back to Portland. She's now at Wise Kadish. I'm at Brownstein Rask. She focuses only on family law. I'm more of a general practitioner, but because I had that opportunity to shape my experience during my time as a generalist out in Eastern Oregon, I applied that same kind of framework. So both from my background in business and sales and kind of problem solving from that level to now applying that same kind of framework to clients. And, you know, problems take on different shapes and perhaps different strategies, but at a fundamental level, what people are trying to do is they're coming in and they have some sort of dilemma. And what a lot of times there isn't a perfect legal solution that fits a business problem. And it's not that we're shoehorning in a legal solution, but what we are trying to do is build a solution out of a framework. So it really depends on what's at play, and it can be everything from, you know, some sort of family dispute or a dissolution or a business dissolution to estate planning to something just proactive. You know, I'm looking at getting into a business relationship. What are the potential risks and pitfalls? So having the experience of a lot of litigation, and I've done a lot of litigation, I kind of know based on when a person first talks to me what to look for.
Interesting. Yeah, you draw from a lot of various backgrounds. And speaking of, what drew you specifically to Brownstein Rask, and how does the firm's culture shape the way that you serve clients?
That's a good question. So when I was looking for opportunities around Portland, one thing I knew that I wanted to continue to do was be a generalist. And then I also wanted to continue judging. So when I was one of the nice things about Eastern Oregon was it gave me an opportunity to do contract work as a prosecutor and then later as a judge. So you could do prosecution in the morning in the municipal court, and then in the afternoon you could do a civil practice. And that's what I did for a decade. And then when I moved out here, I wanted to be able to continue being a pro tem judge and having an impact on the community. A lot of times when people come into, for instance, traffic court, that may be their only experience that they ever have with a courtroom system. And that can have a very lasting and dramatic impact about what people think about the justice system. And I like to be that first line so that we're explaining so that people really understand what the process is and what the expected outcomes are. So when I chose Brownstein Rask, one of the things that was interesting and important to me was continuing down that same type of path, and then also being able to be a generalist. Now, as far as the culture, what I wanted to do was set myself up for success, surround myself with other people that are also subject matter experts, but also a quality support team so that when people come in and let's say I'm in trial, we have other competent people that are able to step in and assist in that process as well. And so that's all kind of what shapes and goes into my decision.
Early in your career, what surprised you most about how business owners actually interact with the legal counsel? And I actually want to just step back. What is a pro tem? If you would give us like, you know what I mean? We've got like a lot of acronyms and vernacular. Sometimes we just want to bring that forward.
Sure. Pro tem, and you'll hear lawyers a lot of time use Latin phrases, and I try and keep myself away from that, but it's a fancy term for part-time. You know, it just means that you're once in a while as needed, right? Hired gun.
I love to see that on the resumes as they come through.
Yeah. So that's pro tem. And then let's see here. What was the second part of your question?
So in your career early on, What surprised you most about how business owners actually interact with legal counsel?
Well, I don't know if it was surprising, but one thing that stood out was that oftentimes they will not ask an attorney on the front end. They will try and do something on their own and shape some sort of solution, and then come to the lawyer after the situation arises where it's clearly now a legal issue. You know, somebody's being sued or somebody needs to enforce some sort of contract, somebody's not performing, right? Um, it's not necessarily that it's surprising that people try and do it on their own. It's just how often, right? So it's almost every time that people. It's kind of like I would liken it to maybe regularly visiting a doctor. So people don't, or a dentist. Like people generally don't want to do routine checkups if they can avoid it. They want to take care of their teeth on their own. They want to try and take care of their health on their own. And if you're not getting these regular checkups or routines, I mean, same thing for a vehicle. If you're not getting routine maintenance and scheduled upkeep, then there's things that you might miss. And it's not to say that things will go wrong, because lots of people go through life and go into relationships with other business partners and maybe nothing ever happens. But if it does, that's where if you're proactive on the front end, it can really have a benefit to you later.
Brownstein Rask works closely with entrepreneurs and operating companies. How would you describe the firm's role in a client's business life cycle?
So as far as the life cycle, I would say that they work closely in all phases. So from inception to even wind down, if or buyout or wind down, if that's what ends up happening. But because the firm offers such a variety of services, so a lot of law firms that I see, not all of them, but certainly a lot of them, they specialize in certain areas. Maybe they do business litigation only. So like we call it like maybe a business divorce, where partners are trying to break up how the company is structured. And some law firms only specialize in that area, or some firms specialize in M&A, mergers and acquisitions. Some companies specialize in taking companies public. What's different about Brownstein Rask is because we service clients in other areas of law. So, for instance, dissolution of marriage, estate planning, criminal law. Because we service these other areas, when a person comes in and some situation naturally arises that may impact the outcome of the business, we're able to advise on those different areas strategically, right? So let's just say that we have a business partnership agreement, or we're doing some sort of amended shareholder agreement, and we know that one of the business partners is married. Oftentimes, what may be missed is that the business partner may know that their marriage is on the rocks, or they really should get their significant other to sign off as the spouse to the shareholder agreement, or that either a prenuptial agreement should be in place or a postnuptial agreement or something like that. I mean, there's all these different directions that it may go, but understanding the different risks of the different areas of a law allows a company like Brownstein Rask to do service their clients in more than one area and kind of think about those different possible outcomes.
What does it mean to practice and act as an outside general counsel for business?
Yeah, so the difference between outside and inside general counsel is that generally, if you're an inside counsel, you're employed by the company. So we've got this LLC, for instance, and they're operating, and they're now at a large enough scale where they have frequent issues that are rising. Let's just use a software sales SaaS company, and let's say that they're at the point where they've achieved enough sales where they're very regularly engaging with customer contracts or third-party contracts with other entities, or they have hiring and firing issues. And they're frequently butting up against, or maybe they have security issues, compliance issues, but they're frequently butting up against these issues on their daily practice. And in the past, maybe they had hired counsel every time one of these things had arisen. Well, they're at the point where they realize they're spending so much money on outside counsel, they might as well spend the money on inside counsel to get that advice. And generally, what inside counsel does is they will try and resolve the problem if they can internally, whether that means using their internal forms, systems, practices. But once the situation rises to a level that exceeds the scope of their agreement of what their general inside counsel is going to be, then they'll refer the matter to outside counsel. And that may be when it's clearly going to be a litigation bound issue that you're going to hire outside counsel, because you don't want your inside counsel working on litigation matter. They can be offering advice to the outside counsel, and often they act as a conduit between the outside counsel and the other C-level executives, the decision makers or the board. They're often the ones that are kind of explaining what's going on in the litigation process, if that makes sense. But that's really the distinction. Oftentimes, people will use outside counsel until they rise to the level of being a large enough company. Usually it's in terms of sales. And then they will hire inside counsel and use inside counsel for as many matters as they possibly can until they get, usually, like I said, it's litigation.
From your perspective, what separates the reactive legal work from proactive legal strategy?
And that's a good question, too. If we're looking at something reactive, what we're doing is oftentimes we're waiting until either the problem arises and it's at your doorstep, so this is like the barbarians at the gate, where that situation has actually arisen and the problem is no longer within the person's control to solve in a number of different ways, right? It's now limited probably to litigation or dispute resolution in some way. So at that point, oftentimes what's happening is people are falling back on lawyers. They're kind of retreating to their prospective camps, and then they're pulling out the legal paperwork and they're looking through those contracts and they're trying to find the provisions that protect them, right? And then they're figuring out what is the way that litigation is going to proceed. Is there a mediation clause? Is there an arbitration clause? Is there a litigation clause? What's the forum? What's the venue, right? Is there an attorney fee provision? That's reactive because you are now waiting until the problem has arisen such to the point that you're falling back on the contract to take a position and take your next step. Whereas proactive is, and this is kind of hard and it's difficult because if you are looking at something proactively, by nature, you don't know exactly what you're looking for. You're asking for advice about something, right? So this would be akin to I can't give financial advice ethically, right? So what I lean on a lot of times is financial advisors, right? So let's just take a case like, let's say we're doing some sort of a business dissolution. We're trying to value assets. We're going to hire experts to do that valuation, right? We are relying on those experts to give certain opinions and reach certain conclusions. If you're getting proactive advice, that means you're talking with attorneys early on in the life cycle of the business to look at those potential pitfalls before the issue has arisen. So really if we're looking at a continuum or a timeline, it's when in time the person is reacting to the problem. Is it before the issue has arisen or is it after? And that's the difference for me between whether it's proactive or reactive.
Contracts. Let's talk a little bit here about these. They're foundational, but they're often rushed. So what are the most common mistakes that you see business owners make in contracts?
I think that you hit the nail on the head. Seth, it's really rushing. It's the first thing that I do when a person comes into my office and they're ready to sign a contract, they have it in hand and they want it done and they want me to look it over and go, bless, this is blessed. Go ahead and sign it, right? But the first thing I have
Okay.
to do is say, we need to take a step back and realize that you are literally getting married to this person in such a way that everything is going to be financially intertwined for
Mhm.
the duration of this relationship at least, and unless we have some sort of unwinding provision or some sort of contemplation within the agreement about how that's going to work. But most of them don't have an end date or a wind down provision in there, right? So um, the first thing I have to do is make them take a step back, and we say, what is it that you want out of this relationship? What's your goal, right? And that forces the person to really slow down and take a step back. And then I say, okay, well, if you're trying to do this, then we go provision by provision. Does this achieve what the outcome that you're trying to get is? So um, that's the first kind of thing. The second is, and it's not necessarily a mistake because usually when a person has a lawyer involved, most of these things are not going to get missed. The problem is when a person doesn't have a lawyer involved, and that's where the mistakes get made. So if you're using an online form, something that you printed off the internet, if whoever is making the contract and printing it off, whatever input they put in at the beginning, if they make a mistake at one portion of the contract, it gets repeated throughout the contract. And these contracts, if they're online generated, it's kind of a garbage in, garbage out. So if you don't put the correct information in, or you have kind of a fundamental misunderstanding, a fundamentally flawed assertion in the contract, then it's going to be repeated throughout. So that's kind of these flaws. I mean, obviously, one size does not fit all, also with these online forms. And there are things that a lawyer can anticipate that online forms just simply can't. Now, I haven't seen it as much yet because it just hasn't been around as long. But as we look at the proliferation of AI, and people are going to start looking more and more to pick your favorite version, GPT, Claude, whatever it is, right? If you're asking one of these large language models to produce a contract for you, what it's doing is, first of all, it can have hallucinations, which means that it's going to give you fraudulent or misconstrued wrong information. That's number one. And they call them hallucinations, which is kind of a fun colloquial term, but it's a mistake, right? And
Mhm.
they can't be held accountable. You have no recourse for that. If I hire a plumber to do a job in my house and then there's a leak afterward, I have a fallback. I can ask them to come in and make repairs or ask for their insurance to cover the damages. If you use ChatGPT, you don't have that same protection. And that's the other protection that a lawyer provides is they're basically acting like an insurance policy for that contract. So not only are you getting the good advice, but you have an insurance policy, right? Um, the other thing with these large language models is that they're pulling data potentially from competing venues, competing jurisdictions with law that's not applicable to wherever your jurisdiction is. So I'm in Oregon. I'm trying to pull a contract and I tell ChatGPT I'm in Oregon. I want an Oregon contract. What if it puts in that venue is in Delaware? And I don't know, to look for that. And they go, well, every contract that we've ever seen says we want venue to be in Delaware because that's most advantageous to business owners from our perspective. And we think that that's what you really mean. Well, now you've kind of set that up that you can only do that in Delaware absent some sort of subsequent agreement. So I know that I'm kind of answering this in a funny way because I keep going from these things to these things. And I guess the point that I would make is that this is the point of having an attorney is there is no one direction. It really depends on what a person's trying to do. And that's why you really need to sit down and figure out what is the goal first.
It's fun that you brought up AI in that because you know, not that long ago, it was the whole legal whatever online that you want to go to for your contracts, and then that was the kind of the I don't know, just a different model that people were coming from.
Right.
Now, I'm curious, like how many people are walking through the door with that contract, and they're like, "Oh, I've AI'd this thing, proofed it, and we should have no problems, or that's what their mentality is these days in the DIY world.
Yeah, so I kind of think about this. There's a analogy for people going into a medical doctor's office and using the medical school of Google that they've self-diagnosed what
Right.
their ailment is, right? Um, Obviously, Google doesn't have your medical history, doesn't know who, you're putting in you're self-reporting your symptoms. It's going to be the same thing with AI, right? I mean, it just doesn't know enough about you to make an informed decision about your situation. We saw in probates and dissolutions after, these LegalZoom and these kind of online forums, there was a lot of unwinding and mistake mending that attorneys have had to do, especially when it comes to wills. And, for instance, let's just take a will as a good example. So there's certain requirements that a will has to have in order to be valid. And anytime that a person takes an original will and then does some sort of holographic amendment to it, right? There becomes this question about whether it's valid anymore or not, or what the original intent, or was this an original part of it or not, right? And that's the type of thing that if you would have gone to an attorney and said, I need to do a codicil or an amendment, then they would either say, okay, that requires a new will, or we can do a codicil or whatever it is. But when people are doing these things on their own, the problem is that they may not be legally compliant or legally sufficient. So I think that AI is a really interesting tool. It's still very nascent, and I think that there's a long way to go. And it definitely has applications that are going to be broadly useful, and especially for attorneys. I mean, there's things with, for instance, in discovery. So we can have these complex litigation cases where we have tens of thousands, hundreds of thousands of pages of discovery that realistically you could not have a lawyer or a team of lawyers look through efficiently, that you can now have AI index and search through, right? And it's probably going to do a better job much more efficiently than a team of lawyers. I mean, certainly you would prefer to have a team of lawyers, unlimited time and unlimited resources, but that's not reality, right? So there are going to be very useful applications that I can see for AI, but wholesale relying on it in absentia of a lawyer is not a recommended path.
Are there particular clauses or deal points that tend to cause disputes later if they're not addressed carefully up front?
That's an interesting question. My experience has been more around the essential terms of the contract. So we're talking about the Q-tip things, the quantity, time, identity of the parties, the place, the price, like those types of things are usually the things that people are arguing about. It's not so much about like, hey, do we need to include an integration clause or not? One thing that can come up is if there's multiple writings before the final contract and you don't have an integration clause, whether those can be used as parallel evidence later, like extrinsic evidence of the intent of the parties, right? That can kind of come up. But usually careful drafting means that all the attorneys agree, and you've heard the term boilerplate. And the reason it's boilerplate is because almost every attorney agrees that it's a good idea to have these things included. And every competent attorney is going to have boilerplate in their contracts that they agree with. And so what's really left over is those kind of essential terms. Those are the things that I think get negotiated more.
Let's talk a little bit about risk tolerance. And when founders or executives are making legal decisions under time or financial pressure, how should they be thinking about that?
That's a really good question. I think that this is one of those things that everybody is going to be different with their level of risk tolerance, and then also their reaction to stressful situations, right? Different people have different coping mechanisms. They have different levels of things that it takes before they actually reach the threshold of being overwhelmed. some people can have a lot of plates spinning, keep a lot of information in their head, and some people can only do one thing at a time. I think at a very base level, what people need to understand is what is their level of sophistication with any particular contract. Where are they going to need help, and when are they going to start listening to advice versus when are they going to follow their own intuition, right? Now, a lot of times when a person will meet with an attorney will say, I'll give you this advice, and this is legally what I think you should do, but ultimately I can't control which direction you go. You have to make your own decision. This is the risk, but you can still do this. Basically, I don't advise you to sign this, but if you ultimately decide to sign it because these are the risks involved, then go ahead and do it, right? You're your own independent person. You're a free thinking individual. You have autonomy. Go ahead and make that decision. I think that that's really where it can become difficult for the individual is they're getting advice from a lawyer they hired and they're paying X amount of dollars per hour. And now they are in this pickle because they feel like they want to sign it. And the lawyer is saying, we really need to change this provision. And then they ask for a change and they redline it back to the other side. And the other side says, I'm not willing to make that change, or I'll change it in this way, but it doesn't completely eliminate the risk, right? That's the point at which the person goes, okay, my lawyer is telling me not to sign because they can't tell me to sign because there's this risk, right? But I want to sign.
Mm-hmm.
How do you think about that, right? Well, we can make a list of pros and cons. We can, consult a Ouija board. There's all these things that people might do, but ultimately they have to make their own decision, right? How should they approach that? That's a great question. And everybody is going to be different about what I tell that individual person. It's going to be so personalized based on their personality traits, really also their mix of businesses that they have. Have they done this type of a risk in the past and been successful? Have they been successful if it failed and they had to go through litigation? What was their reaction when they went through litigation? Were they overwhelmed and they just wanted to settle? How did they do in their depositions, right? If they haven't really been through litigation, I'm going to walk them through what litigation is going to be like and what to expect. Not just what the risk is, but if they're in breach and they have to go through litigation, what's that going to feel like? What's that going to cost? That's the kind of thing that they need to know about. But if their risk tolerance is really high and they've been through litigation before, they're probably going to be able to make their own decision. I don't know if that's helpful, but
well, it's the first time I've ever heard Ouija board brought in for a risk paradigm and what kind of a model you're willing to work with.
It's a terrible idea, but I mean, people do all sorts of strange things that are completely irrational when it comes to decision making, right? Yeah. I mean, we have to recognize that everybody has their own idiosyncratic quirks, and we then have to explain it on terms that they can understand and identify. Because if we're not approaching the person on their level in a way that they can understand, I think we're doing a disservice to them because we're just explaining the legal potential outcomes, but they're not really understanding it, right? So that's why I say it like that.
All right. Well, partnerships and shareholders' relationships often start with optimism. Where do you see those relationships break down most often?
Yeah, I see them break down actually in not so much in the personal relationships between the partners, but relationships outside of the business. So something external happens that causes a complication internally. A person gets a DUI or a divorce or something like that, and it causes some sort of strain on the business. Now, most of the time, if a person's entering a business partnership with we have two individuals and they're entering a relationship together. Most of the time, they have a pretty good understanding of each person's personality, and they should know, I mean, they probably do know the strengths and weaknesses of each side, right? What's this person going to be what's the title of this person? What's their role and responsibility versus my role and responsibility, right? those things have all been defined. And then we've probably also defined, is this a 50-50 shareholder agreement? Is there some other distribution of who's the decision maker here? How are we making the decisions? How often are we meeting? If we have a disagreement, how are we coming up with that? And they should, or they probably already do, understand where that friction is going to arise. So I don't see it so much in that where it's the person's relationship becomes strained with their business partner. It's usually something external. That it's not to say it doesn't happen. It certainly does. It's just not the frequent situation.
So if a business senses internal tension brewing, what steps should leadership take before the legal teams are formed or get formally involved?
That's a good question, and it's going to depend on the business structure, the ownership. How the business is structured as far as equity. Is there a board, and do we need to involve the board? At what point do we need to do that? Versus, are we just talking about two people in a partnership? So that's the kind of first level of questioning, is who needs to be involved in this decision making. The next thing we need to look at is we need to look to our operating agreement to see if it talks about this. Because sometimes shareholder agreements will talk about conflict resolution, including internal dispute resolution, right? So it may say, should an internal dispute arise, these are the steps that we're going to have the people take in order to see if they can resolve it first. And it may even talk about something like the parties agree to mediate the resolution, or whatever it is. Go talk to this person or whatever it is. So we need to look to those articles of the business before that. Now, if everything is silent, if all of the documents and everything, there's no other direction about it, then and the partners are truly in friction and they're not able to sit down and talk about what the appropriate next step is, that's when I say that you've got to talk to your attorney and get your team involved to start figuring out what the game plan is. Now, your team that you're using not only includes your lawyer, but you're going to use your CPA or CFA. You're going to include all of the people that are potentially going to be able to provide you your expertise and your counsel on making the next decision. You shouldn't be relying on any one person at that point, right? So that's usually what I would say is the typical chain reaction.
So not every dispute needs to go to court. And how do you
Certainly
help
not.
clients? How do you help clients decide when to resolve issues informally versus escalate?
And I think that we need to, since we were talking about conflicts between partners, let's also draw a line between conflicts between either other customers or other, other SMB relationships, other.
Right.
It's really going to depend on the nature of what we're talking about for when we're going to escalate this to litigation, right? So my general recommendation, and this is going to be case by case, but my general recommendation is that if we're talking about some sort of internal conflict and the business is going to be better off by resolving the conflict, then we should just resolve it internally and no litigation should ever take place. If the business and everybody is going to make more money by resolving it internally, that's what should be done. If it's not resolvable internally, that's when we go back to that attorney and team to get recommendations for next steps. Now, as far as other external conflicts, when should we resolve them? This is the same kind of thing. If it makes more sense, if we have a long-term business relationship with a customer that makes a lot of money, this is the analysis that a lot of people go through every day. Let's just say I'm a mechanic shop and I have a deal with the local police agency and I service all their vehicles and they come into my shop and I do repairs for them. And let's say I send back one of the vehicles and the captain calls me and he goes, "Hey, my brakes are still squeaky on this squad car," right? send it back and repair it, no cost, right? It's more important that we keep that relationship than we say, we fixed it and you must have done something wrong and it's still under a warranty and, start arguing about it, right? We're going to have to look at the relationship that we have with that customer and do a cost benefit analysis to see how much is this going to cost us to fight over this. And there's a difference between being right and making money, right?
Mhm.
We don't have to always be right to make the most money. And oftentimes we're right, but the best thing to do is not be right and go prove it. It's to just go, yeah, that's great. Let's just move on. And a lot of times that's what I'm doing. They jokingly refer to us as, or they say we're counselors, right? And I jokingly refer to us as counselors, like in the other sense. And a lot of times I'm just listening to the issue that's arising. And I go, yeah, that sounds really bad. And I feel for you, but do you really want to fight about this if this is a really great customer, or do you want to just move on? And a lot of times they just move on. So I think that that's the analysis that needs to be done. And if you're on the fence, that's when you bring in the lawyer. But if you're not on the fence, if you can kind of see this is a good customer long term, it's not going to cost that much. Okay, I have to eat a little crow and I'm actually right on this, then you have to just swallow it and move on, right?
Would you rather be right or would you rather be free?
That's right.
Yeah.
That's the
Are
question.
are there moments in this scenario, let's say, where early legal involvement can actually save the relationship, not just the money?
Oh, for sure. Because a lot of times when people first come in, they have no idea how much litigation is actually going to cost. And they don't realize that, hey, this is actually pretty expensive and going to be very time consuming. So,
I'm sorry, can you pause right there? I had a
sure.
printer going off behind me, and
Yeah,
just give it a couple second pause. I'm going to go ahead and start that question over again.
sounds
Okay.
good.
Awesome. Thank you. 1 second. All right, we were talking about relationships, and I want to stop there for a minute and ask you about early legal involvement can actually save a relationship, not just money.
Oh, certainly. So, what I notice a lot of times is when people first get involved in litigation, they don't realize how expensive it's going to be and how time consuming it's going to be. And so, early intervention from an attorney to review the factual matters, review the legal issues, and provide that early advice can help at least expectation set for the person facing that litigation, what it's actually going to be like, and then potentially look at resolutions outside the forum of litigation. And there's all sorts of alternative dispute resolution that may be available.
Let's talk a little bit about some trends and what you're seeing in business law right now among small and mid-sized businesses in Oregon or even broader Northwest. If you expand that, what are you seeing inside of the trends?
So the trends for businesses or legal,
Yeah,
which,
well, actually staying within the business law scope.
okay.
Where do you see those trends happening or following right now?
Well, I think that, I know that this is perhaps we're trying to do kind of evergreen responses. And so this may change from time to time. I think that there's still generally some economic uncertainty, and people are trying to keep powder dry. So I think that anytime that people have uncertainty about the economy or what's going to happen next with tariffs or any other issue that might arise, I think people tend to take less risks. And so what you see is that people stay within their current what they're doing as far as their business, who they're servicing, what services they're providing, what they're producing. That kind of stays stagnant, and they're not really taking any new risks. They're not spending money on R&D, right? So that's a lot of what I'm still seeing, is that people are kind of staying within that mindset. And I think that, at any given time, we see expansions and contractions. And at some point when people start looking at expanding again and expanding R&D or opening up to new markets, that's when it makes sense to start talking to lawyers again to ask what are the potential ramifications of expanding into these different areas? Do I have any legal exposure or risk in those different areas?
How is the role of a business attorney evolving then as the companies are starting to move faster and really operate across multiple jurisdictions?
So one thing that you'll see a lot is that attorneys will appear pro hoc vice. Is another Latin term, but it means that you can appear in other states, right? So let's just say there's New York litigation. I've been representing an Oregon client, and they have a customer in New York, and New York brings an action. This New York company brings an action in New York, and then I filed to appear pro hoc vice in that case in New York, right? You're seeing that more where you have these really large firms that are appearing throughout the country and focusing, you get attorneys that are focusing on a single area of litigation, right? And that's not necessarily anything new, but that's something that's happening a lot is business lawyers and specializing. I did talk about that a little earlier too. But I think that I think that the evolution of that is going to be that you're going to see, especially as we kind of talked about with new technologies and AI, I think that the role with the lawyer is so it comes back to what's really funny about this is the more that we get into technology and the farther we get along with new products, the more important relationships become, in my opinion. I think that that's where it comes back to having a trusted advisor that understands your business and you. And we talked earlier about risk tolerance and risk aversion and things like that. If you have a lawyer that really has a deep understanding of not only your business, the assets you own, the employees that you have, what's important to you? Is it offering employees the opportunity to retire early with a good compensation package? Is it to someday turn the company into an employee-owned company? Is it to give back to the community or a particular charity, right? If you as the attorney have a really deep understanding of the business and the business owner's goals, then you can provide and you have that relationship that you can give that direct feedback to that person. I think that that's where it becomes more and more as the technology evolves. It's almost like the fundamental role of the attorney goes back to square zero, right? The original intent of an attorney almost seems to be the relationship, and that becomes so paramount. You can't have a relationship with ChatGPT. I suppose you could, but it'd be
People are trying.
very bizarre, dystopian, right? But
Yeah.
That's what I think is it just becomes so important. And you look at every other profession, you look at your realtor, you look at your banker, you look at your CFA, you look at your accountant. I said your financial advisor. You look at your insurance broker, like all of these people, it comes down to the relationship, right? Do you trust this person that you're working with? And if you don't trust them, you don't continue to work with them. If you get bad advice, you don't go back to them. So that's what I think becomes the most important thing for the lawyer is, number one, if you're a lawyer and you don't know the answer and a person's asking you, it's okay to say, I don't know, and give me a second to get back to you, right? Take a beat. And number two, your reputation is everything, right? And your working relationship with these people matters, and that you do what you say you're going to do and they do what they say they're going to do. That's what I think it comes back to.
Well, you're already going down the road that I was hoping we'd get to, where that's your collaborations and this bigger picture inside of the collaborations. And you work alongside CPAs and financial planners like myself and other advisors. And what makes those collaborations successful in your experience?
Oh, and it sounds like I did go down this path because it's this reciprocal trust, right?
Yeah. Right.
It's the relationship. It's that when, let's just say that we have some sort of client in common and you've been giving financial advice to a person and you go, hey, tell me about your power of attorney, or tell me about your advanced medical directive because you know they're having some sort of health issue, or tell me about your estate plan, or tell me about how are you going to what's your business succession plan, right? You can get into these different discussions with the person and you have a very deep understanding of the person, and maybe they have a really good relationship with you. Maybe you know them outside of just work, from out in the community. You have some sort of involvement with them and you have a special relationship with them. That bridge that you have can be so critical in building that connection between the advice that now I'm going to provide to them, because you're saying, this is my trusted partner. It's my trusted advisor for a situation that's similar to yours. And then the most important thing is that the person follows that advice, right? Now, I talked about that the people have autonomy and they're going to make their own decision, but a lot of times they're going to follow the advice of their trusted advisors. So, number one, like I said, since I'm an attorney, I can't give financial advice. So I have to know my lane. I have to know when to bring the person in. Hey, the person is now asking a financial advice type question. Who am I going to bring in? That type of a thing, right? No, this person's asking a tax question. I'm gonna bring this person in because it's really a complicated business tax avoidance type question. So I need to bring this person in. Oh, this person just won the lottery. Who am I gonna, they just got $90 million. What am I gonna do now? Who should I bring in for that situation? You need to be able to address all of these and have a team of people that you're able to collaborate in any given situation. And that's what I think is so important.
Where do you most often see these disconnects happening between the legal, tax, and financial planning, and how can those gaps then be closed?
I think that's a good question too, and that's hard to answer because every situation is pretty unique, as you might imagine. Because
Sure.
it seems like people get blind spots about unique things that are probably specific to them. I've got a lot of folks that grew up in the Depression era, for instance, or they were first generation after Depression era. And so they have a different mentality or mindset about assets, goods, holdings, things like that. And they get blind spots about other things, right? Kind of recognizing, I think that because the situations are so different for each type of person, it's going to be kind of hard to generalize it. But I think that this goes back to a little bit when we were talking about risk tolerance, and I was talking about people being so different and needing to understand where they may have shortfalls or where they may have blind spots. That would probably be something similar to what I'd answer for here, which is, I hate when lawyers give non-answers, but unfortunately, that's what I'm going to have to do.
I won't nail you down on that. I won't be too hard.
Oh, you
Uh,
can, and I'm an open book, but I think that one's hard.
okay. If you had to give business owners three legal habits that they should adopt immediately, what would they be?
Three legal habits. I think that everybody, if they're not already, they should be doing annual meetings with this team of folks that I was talking about, at least
Right.
annually. I mean, ideally, you'd
Yeah.
be doing it quarterly, but a lot of people aren't even doing it annually. They're not having annual meetings with their lawyer to review any business or estate planning documents. They're maybe not even doing meetings with their financial advisor annually to review what their investments are and what their strategy is for the coming year based on the changes. Are they all heavy market cap? Like, what are they doing for the next year? They don't know. They're just relying on the person. And then sometimes they're making decisions in their business based on bad assumptions about their investment portfolio or a misunderstanding about their holdings, right? They should be meeting also with their accountant well before the tax year so that they're making strategies in advance of doing tax returns, right? You shouldn't be doing any sort of any sort of business management around taxation based on the returns. That's reactive, right? That's when the issue has actually arisen. You should be doing it before, right? You should have a strategy in place. So for sure, number one with a bullet is you should be meeting with your team at least annually, if not quarterly, or even more frequently, if it makes sense. Number two, I think that you should have a very clear, and one of the mistakes that I see most often is succession planning, right? So this is where we're talking about what happens to the entity in any sort of situation, whether it's a dissolution of marriage, whether it's a death of a partner or a member, what's going to happen to this entity? And also, what do I want to have happen? Do I want to do this generationally? Do I want to give this to my employees? What's the succession plan, right? And having a strategy around that. And if you don't, then, asking your advisors at that meeting that you're doing about what they might recommend. And then the last thing is most folks have a lot of contracts that are old and they haven't been reviewed for a really long time. They could be a 10-year-old agreement that they have with a client. I don't think it hurts to have those reviewed by an attorney to see if there's been any changes in the law, right? And those changes to the law could impact taxation. They could impact the way that they're, at what the different brackets that people are purchasing at, or it could be something like an employer-employee type of a contract. I mean, there are so many different areas where laws change all the time. And I'm not saying that it requires that a 10-year-old contract be rewritten. I'm just saying that they should be looked at so that they can get advice about if there's been any changes.
Well, this actually, what would be considered old inside of those contracts? How often, would you want to take a look at those and make sure the provisions are up to date?
So I'm looking at first estate planning every 3 to 5 years because there are changes in the federal exemptions pretty often. And so we're needing to do tax planning changes every 3 to 5 years. And then for business contracts, you're inside, we talk about if you have inside versus outside counsel. If you have inside counsel, obviously those are getting looked at very frequently, right? But if you don't have inside counsel, if you're just kind of a business and you're either hiring outside counsel on a case-by-case basis, then I would say between 5 and 10 years, there isn't a magic number because it's hard to say because what if a law changed the next year after you did a contract and it just happened to be that law changed? I mean, certainly if you have employer-employee contracts, those are changing more frequently than contract law, right? So contract law is usually changed through case law or, it could be changed by the statute, but that's less frequently. But the changes that we're seeing more frequently are in employer relationships.
Okay. Well, final question. When business leaders say, we'll deal with that legal later, what do you wish they understood about that mindset?
That it could be resolved now and it may not be able to be resolved later absent litigation. So I think that an analogy here, you've heard me give a lot of analogies, but I think a really good one is if you have, let's just say you have something small go wrong with your car. Let's say you have the tire pressure gauge goes off and you recognize that it's not sensing the tire pressure anymore. And you go, I'll deal with that later because it's not a big deal. I still know that the pressure's fine or whatever. And then the mechanism to change the rear view mirror stops working on the side view mirror and now you can't adjust it, right? And you go, oh, it's okay. I can kind of see. It's fine. I'll deal with that later. And then one of your windshield wipers breaks and you go, well, it's summertime. I'll deal with that later, right? The problem is that eventually these issues compound and what would have been an easy fix and a small solution has now been compounded into a big solution or big problem and an expensive bill. Because when you eventually take this vehicle in for maintenance, you're going to have a much bigger bill when they're fixing everything than if you would have just fixed the one thing, right? That issues compound. And especially in vehicles, issues can compound because if you ignore one maintenance thing with your vehicle, a lot of things can go wrong. It's the same with your business. If you ignore a small thing, it can turn into a big thing. And I know that people say, I'll deal with this later. It's not on fire right now, and I got to go deal with this other thing. I respect and appreciate that. That's a perfectly valid and reasonable position. But what we need to do is set a deadline that we're going to respond to this so that a small thing doesn't become a big thing later.
Put it in your calendar somehow, some way, make sure it gets addressed.
Docket it. Yep.
Well, thank you, Blaine. Really appreciate you joining us today and breaking down how legal strategy really shows up in real business decisions and not just in courtrooms or in crisis moments, but in contracts, hiring, partnerships, and growth planning. Appreciate you.
Thank you, Seth. This has been very fun to do, and I like the way that you ask your questions, so appreciate it.
My pleasure. One of our biggest takeaways from today is that good legal counsel isn't about slowing business down. It's about helping leaders to make clear and more confident decisions before small issues become expensive ones, as you just highlighted for our listeners. And if you are a business owner or an executive or an investor who wants to be proactive rather than reactive, you can learn more about Blaine and his team at Brownstein Rask, and they'll work more closely with you there and with closely held businesses and entrepreneurs who help manage risk, navigate complexity, and protect long-term value. As always, thank you for tuning in to Sterling Insights. If this episode was helpful, please follow for more and share it with someone in your network to leave them with something that's valuable for them. And leave us a review, and it always helps to bring this conversation forward with professionals who you operate with and in that intersection of strategy, finance, and law. I'm Seth Krussman, and this has been Sterling Insights. And until next time, stay intentional, stay informed, and keep building wisely.
Thank you for listening to another episode of Sterling Insights. Stand out and supercharge your assets, where we provide the info you need from successful leading financial advisors, lawyers, and CPAs. Your hosts, Roger and Catherine Silk, invite you to learn more about Sterling Foundation Management by visiting sterlingfoundations.com.